Hello, I'm Alice Smith, founder and executive director of the National Voter Corps. The 2016 election was a catalyst for me. I watched the fundamental right to vote being systematically denied or made difficult to exercise in Georgia, North Carolina, Ohio, Wisconsin, Michigan, Louisiana, to name just a few of the states. How was this possible? I'm a lawyer, yet was unable to explain how 50 years after the passing of the Voting Rights Act, I witnessed vote suppression at a gigantic scale. This talk is the result of my determination to answer that question. The slides that make up this presentation are available on the National Voter Corps' website for reuse, and this talk will also be available. First, we will examine voting rights through the legal framework of the Constitution. How voting has been suppressed by the Supreme Court decisions and state actions, and finally, congressional inaction. And at the end of this talk, I will provide links to a curated list of effective groups working for one person, one vote, and every vote counted. This is a roadmap to my talk. The right to vote is not guaranteed by the U.S. Constitution, and as a result, many branches of government, Congress, the federal courts, state branches of government, and finally voters in some states through initiatives and propositions affect voting rights. But let's look at the Constitution. In Article 1, Section 4, it's the election clause. The framers left the times, places, and manners of holding elections for senators and representatives in each state by the legislature of that state. But Congress may at any time by law make or alter such regulations, except for the place of choosing senators. Initially, senators were chosen by state legislatures, not by the people. Please remember this clause. Congress may at any time make or alter. But if they don't make a law, the power resides with each state. Article 4 Article 4, the right of self-determination for each state, and the 10th Amendment sets out the reservation for all rights not granted to the federal government to the state. So the strict interpreters of the Constitution turn Article 4 and the 10th Amendment to argue states' rights, not federal laws, control their behavior unless it conflicts with express federal laws or clauses of the Constitution. The 14th Amendment was passed in 1868 at the conclusion of the Civil War. Therefore, all persons born or naturalized in the United States are citizens of the United States and of the state where they reside. No state shall have the opportunity to make any laws abridging the privileges and immunities of citizens of the states, or deny any person within its jurisdiction the equal protection of the laws. The Equal Protection Clause has served as a keystone for protecting civil rights of minorities and persons in the United States, whether or not citizens. In Section 2, the number of Congress representatives has to be apportioned among the several states by the number of persons in each state, excluding Indians not taxed. Note, for the purpose of apportionment for Congress, it's the number of persons. It does not say citizens. Every 10 years, there's a census required by Article 2, Section 1 of the Constitution to determine how many representatives a state would have and to determine the direct taxes for the federal government. In 1868, some Indians were not taxed by treaty. Thus, such Indians would not be counted in the census. But note, all others were to be counted, whether citizens or not. Under the 15th Amendment, passed in 1870, the rights of citizens to vote could not be denied or abridged on account of race, color, or previous condition of servitude. Thus, the slaves had all rights of citizenship. Thus, there should be no denial of the right to vote based on race, whether or not a former slave or indentured servants. The 17th Amendment, which was passed in 1913, took away the right for state legislatures to elect U.S. senators and granted to each eligible voter in the Senate the right to vote for their 2 U.S. senators. The terms for each senator was set for 6 years, and each U.S. senator had 1 vote in the Senate. 3 more amendments impacted the right to vote. In 1920, the right for women to vote. In 1964, the poll tax, as a critical part of the civil rights movement, was altered, making it clear that the right to vote could not be denied or abridged by the failure to pay any poll tax or other tax, which had been a tool of the southern states to deny the vote to blacks, browns, and poor voters. Eliminating the poll tax was a major victory to access to voting. In 1971, the 26th Amendment reduced the voting age to 18. Turning now to Congress. Throughout the years, Congress did use its powers under the Elections Clause, Article 1, Section 4, to set rules for regulating voting. After Reconstruction, Congress rescinded many rights granted to minorities during the period of Reconstruction, but I will skip to 1924, when Native Americans were granted citizenship under the Indian Citizenship Act. Then in 1957, the Omnibus Civil Rights Act was passed. This set up the Civil Rights Division of the Justice Department. Resistance was profound in some states and in local federal district courts in those same states. During the years leading up to the 1964 Civil Rights Act, according to Wikipedia, the African American voter registration rate in the South increased only marginally, even though the department litigated 71 voting rights lawsuits. In 1964, Congress passed the monumental Civil Rights Act. Martin Luther King had been lobbying President Johnson to eliminate literacy tests, one barrier to voting rights for blacks, browns, and poor whites, and to address economic retaliation, police repression, or physical violence against non-white voters. While the Civil Rights Act did require that voting rules and procedures be applied equally to all races, it did not abolish the concept of voter qualification. It accepted the idea that citizens do not have an automatic right to vote, but would have to meet standards beyond citizenship. The Voting Rights Act of 1965 directly addressed and eliminated most voting qualifications beyond citizenship, close quote. The Voting Rights Act sought to enforce the 15th Amendment, circumvented after Reconstruction by Congress and the courts. In Mississippi and other states, people were being killed fighting for their right to vote. The 1965 Voting Rights Act prevented states from requiring specific voting qualifications, such as literacy tests, which in many jurisdictions were prerequisites to registering to vote. A simple X could be used to sign a name to the register to vote. Section 2 applied to every state and prohibited practices such as intimidation, violence, or other standard practice or procedure to deny or abridge the right of any citizen of the U.S. to vote on account of race or color. Under Section 4B of the Voting Rights Act, there was a formula to determine which states or other counties were required to have preclearance before any law, practice, or procedure relating to voting could be changed by that state, county, or township. Section 5 made it clear that the states or other counties or townships covered by the preclearance formula were required to apply to the Federal District Court in Washington, D.C., or the U.S. Justice Department to obtain clearance before changing any such law, practice, or procedure relating to voting. By 2013, the Voting Rights Act applied to 9 states completely, 5 states by specific counties, and other states certain specific townships with a proven history of discrimination, including low voter turnout. There were many attacks against the Voting Rights Act over the years. The Voting Rights Act had been amended many times, including but not limited to changing the formula in 1970 and 75, adding minority language requirements, giving voters assistance at the polls, providing for voters with disabilities, and then in 2006, in a compromise after some in Congress tried to scuttle the Voting Rights Act altogether, extended sections 4 and 5 and the other provisions with sunset clauses, which means that it has a term of being in effect and then it stops, without comment for 25 years. The Voting Rights Act meant that millions of Americans previously refused the right to vote because they were poor, of color, illiterate, by example only, were able to register to vote and did register. Voting increased in all states, but especially in the states covered by the pre-clearance requirements. In democracy diverted, polling places closure, and the right to vote, the importance of pre-clearance was clearly stated. Section 5's prophylactic power came from its recognition that harms of voting discrimination can never be truly redressed. Once an election is held, there is no do-over. So here are the states and counties that were required for pre-clearance under the Voting Rights Act, Section 5 in 2013. Note, California had 4 counties. Florida had some counties, Virginia had counties, Maryland, and the states in dark purple were completely covered. Michigan had some townships. There were townships in other states. And then the Supreme Court acted in Shelby County v. Holder. In 2013, an Alabama county called Shelby challenged the constitutionality of sections 4B and 5 of the Voting Rights Act. Remember, that required pre-clearance before you changed any of the voting laws in your state or in a county. And Holder was the United States Attorney General at the time. In this landmark decision, 5-4, the Supreme Court held that Section 4B of the Voting Rights Act was unconstitutional. Chief Justice Roberts, writing for the majority, stated that the coverage formula was based on data over 40 years old, and therefore it was not responsive to the current needs, placing an impermissible burden on the constitutional principles of federalism. Federalism was all laws not expressly put into the Constitution or by federal law were reserved to the states. As a result, without the coverage formula of Section 4B, the pre-clearance obligations for those states was removed. Recall that 7 years before, in 2006, Congress had extended the Voting Rights Act, including the pre-clearance formula, for 25 years without change, and that under the Elections Clause, Article 1, Section 4, Congress was granted the express right to make federal laws or alter state laws. Judge Thompson thought that Article 5 would also be found unconstitutional. In her minority opinion, Justice Ginsburg argued that the evidence gathered by Congress supporting continuing the law, which enforces the 14th and 15th Amendments, and objected, saying, all told, between 1982 and 2006, the Department of Justice objections blocked over 700 voting changes based on a determination that the changes were discriminatory. Between 1982 and 2005, Alabama, who was bringing this action, had one of the highest rates of successful Section 2 suits, second only to its Voting Rights Act covered neighbor, Mississippi. In other words, the Justice Department had sued Alabama for breach of the law, so that throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. Almost immediately after Shelby County decision, vote suppression measures were implemented at the state level and by county and municipal registrars of voters. What follows are examples of systematic voter suppression after Shelby. 1,688 polling places were closed since 2013 in counties previously covered by preclearance. By reducing voting places, research has shown that reducing polling places and reducing early voting hours reduces voter turnout. By removing or limiting voting stations at colleges and universities, student voting turnout was also affected. Organized vote suppression began with purging of voters. There were 17 million voters who were purged from the voter rolls since 2016. Organized purging began by the Kansas Secretary of State Kobach in 2006 in Iowa, Missouri, and Nebraska, not covered by the Voting Rights Act. Section 4 or 5. States not covered were deeply affected. An unreliable software program compared identically named people in one state and another state and removed any duplicates that were found. Eventually, 27 states used it, although 9 withdrew before 2016. For every double vote counted, a Stanford study in 2019 found that 300 legitimate voters were removed. These are the states covered by the Crosscheck purges in 2016. It's unclear whether more states have withdrawn from Crosscheck, but notice that they are heavily part of the same states that were covered under the Voting Rights Act, Section 4B and 5. Voters move from one state to another and register in a new state. And when they register, the registration form provides for sending a notice to the other state, but states don't always follow through. Thus, a voter could be on the rolls in both states, but it doesn't mean people are voting in both states. Significant voter restrictions began in 2010 in states not covered by Section 4B formula. But since then, there have been significant changes. 35 states have implemented voter identification requirements by 2019. But notice those states, the dark purple, were those states which put in strict voter identification. Significant voting restrictions include voter IDs, which are expensive because voters find it difficult to acquire. Many people do not drive. Elderly people do not drive. There are many licenses which are acceptable, but those without a license have to acquire a special photo ID in these strict identification states, which is like a poll tax, onerous for low-income people who have to take time off work to get the required ID to vote. Some states require traveling to the county seat, and some of those counties have reduced the hours for serving minority voters, a practice banned by Voting Rights Act Section 2, which has not been ruled unconstitutional. Since Shelby, more than 10 lawsuits have been brought successfully on the basis of racial bias or intentional discrimination, but the need to bring lawsuits to enforce the Voting Rights Act is exactly what Section 5, preclearance, was intended to prevent: organized, systematic vote suppression of people of race, color, or national origin. Examples of onerous, burdensome changes to the law. North Dakota requires street addresses on voter IDs. In a federal case which the Supreme Court refused to review, Native Americans on North Dakota reservations didn't have street addresses, which was part of their culture. 10,000 or more voters were disenfranchised in 2016 by this law. Utah also. Michigan and Wisconsin did not allow some student IDs issued by its universities and colleges to be used, and some states refused local business ID cards, such as a Google Pass, to be used as IDs where a photo ID was required. 3 states, Kansas, Georgia, and Arizona, went so far as to try to require birth certificates in order to register to vote. But this was ruled unconstitutional because under the 1993 National Voter Registration Act, the only 2 requirements that could be used were either the last 4 digits of your Social Security number or your driver's license. A federal court in 2013 ruled that North Carolina's voter ID laws were racially targeted African Americans with almost surgical precision. In 2019, North Carolina's legislature passed a new voter ID law similar to the 2013 law. The Democratic governor vetoed such voter ID law, and the legislature then overrode the veto. The lawsuit sought an injunction. 2 Superior Court judges ruled in July of this year that the new law won't take place until 2020. A judge would have issued an injunction. Watch this space. Other lawsuits are going to happen, I'm sure. Examples of mechanical errors include misspelled street names on an absentee ballot, signature printed instead of cursive, signature slightly different from the registration card done years before, a misspelled city name, even by 1 letter. In one example, a homeless voter signed his absentee ballot accidentally signing the day's date instead of his birth date. There is no question that this was his ballot, his signature, but Ohio implemented a perfection requirement, and the Supreme Court of the United States refused to hear the case. These mechanical errors prohibited real citizens from voting. Which states have done something to help encourage voting? Early voting makes it easier for people to vote. They don't have to just vote on election day. But note the states that have no early voting. Automatic registration, known as same-day registration, occurs sorry, I'm going back a slide. Automatic voter registration occurs in the states that are blue. That means that when you change your driver's license, or in some instances apply for state welfare, you will automatically be given a voter registration, and that your voter registration will be sent to the Registrar of Voters or to the Secretary of State. And you will receive a card afterwards to confirm that you, in fact, intend to register to vote. And by returning that card, you are automatically registered to vote without filling in another form. So you go to the DMV and you get your driver's license, and you're registered to vote at your new address. Same-day registration occurs in 21 states and the District of Columbia. This is very progressive. It means that if you've moved in the month before you've been elected, you aren't closed out from being able to register at the polls or at the county seat, depending upon the state, and be able to register. California has just passed same-day registration at any poll in the state. Felons in some states are disenfranchised absolutely for the rest of their lives. In other states, such as Maine and Vermont, felons may vote whether they're in prison or not. And then there's a whole variety of different options. But as Lyndon Johnson said, a man without a vote is a man without protection. Restrictive voting rights bills have been introduced or carried over into 2019 at these states that are in red. California had one introduced to try to have voter ID laws, but that did not carry. So these are introduced or carried over. It does not mean that they will pass. Expanding voting rights has happened. Some have been introduced and some carried over. It doesn't mean that they will be passed, but many of these have to do with early voting or looking at 16 to 17-year-olds being able to register to vote in anticipation of their 18th birthday. But one example of suppressed voting is in Georgia. To understand vote suppression from the point of view of the suppressed voter, I urge you to go to Brave New Films and look at Suppress the Right to Vote. Next, what is gerrymandering? Well, the original gerrymander was in 1812 when Gerry, the governor of Massachusetts, redrew the state senatorial districts to favor his party. And you can see that the Boston Gazette thought the cartoon, which merged Gerry and salamander, described the result, gerrymander. And so the term has gone into the history. But what exactly is gerrymandering? Gerrymandering means to manipulate the boundaries of political districts in order to advantage the party in power. Every 10 years, U.S. Census identifies where people live and the number of congressional districts that are allocated to states according to population. Thus, redistricting allocates voters to congressional districts. When state legislatures control redistricting, their political interests are often led to partisan gerrymandering or racial gerrymandering. States which have independent commissions tend to create more balanced districts when specific and fair criteria guide composition of the commission and their mission. How do you gerrymander? Well, the party in power controls redistricting, organizes districts to help its party by packing voters into a district so their party's candidate will win no matter what. In a cracked district, a particular party's voters are dispersed into a district where their vote will have no chance of prevailing. When you crack a voter into a district, that voter's vote is diluted because there is no chance that her party's candidate will win. The systematic pushing of people into or out of a district occurs when partisan factors are used to set voting boundaries. Here are some examples of packed districts. Note the boundaries. Michigan, Maryland, North Carolina, Virginia, Indiana, Texas, and Florida are described as gerrymandered with high partisan bias, where the political party in power gerrymandered the districts to their advantage. Note both the Democrats and the Republicans gerrymander districts. Maryland, by example, went from 5 Democrats and 2 Republicans by packing Republicans into one district and cracking them elsewhere, so that the Democrats got 6 congressional districts and the Republicans 1. States that have independent commissions, as I said, tend to not have this partisan gerrymandering. State legislatures themselves can be gerrymandered. This is obvious since the state legislatures control redistricting. Then when you make sure that the control of the state is in the hands of the party in power, then you are going to affect who goes to Congress, as well as the state laws, such as voter ID laws. Notice purple. Those are 2 Democratic state legislatures which are gerrymandered. Here's Michigan gerrymandering. Republican legislatures intentionally packed Democrats into districts and cracked others to enable Republicans to win congressional seats when a majority of Democrats are in the state. 9 Republican seats to 5 Democrats, while the acquired 64% of the states with 50.5% of the vote. Wisconsin gerrymandering did the same. Blue Democrats over time were packed into fewer districts and as a result had far fewer representatives in Congress and in the state legislature. North Carolina was, the federal court found that North Carolina had systematically used racial and partisan means to redistrict and found that it was unconstitutional. In an impartial 3-judge panel then drew up a nonpartisan base map, which resulted in 3 open or toss-up districts, the yellow, 6 districts which were likely to be Republican, and 4 that were likely to be Democrats. So the blue were the Democrats, the red the Republicans. That same year, the second map, drawn by the North Carolina state legislature, openly and notoriously through partisan gerrymandering, admitted by them, manipulated the maps so that 10 Republican districts, through packing and cracking, were drawn, and only 3 were won by Democrats, yielding the same gerrymandered district as in 2011. North Carolina and Maryland were the 2 cases that were brought to the Supreme Court, and we'll now see what the Supreme Court did after the judge in 2016 had held that North Carolina's packing and unpacking was unconstitutional. In June 2019, the Supreme Court heard 2 partisan gerrymandering cases merged together into Rucco versus Common Cause. North Carolina was Republican gerrymandered and Maryland's was Democratic gerrymandered, brought by the League of Women Voters. And when these cases were heard in the Court of Appeals in Maryland and North Carolina, each of these courts of appeals ruled that the partisan redistricting was unconstitutional. The Supreme Court decision in June of this year, Justice Roberts, writing for the majority, said, quote, Partisan gerrymandering claims have proved far more difficult to adjudicate. The basic reason is that while it is illegal for a jurisdiction to depart from the one person, one vote rule or to engage in racial discrimination in districting, quote, a jurisdiction may engage in constitutional political gerrymandering, close quote. He stated that the Constitution does not require proportional representation, and these questions were beyond the reach of federal courts. He said, excessive partisanship in districting leads to results that reasonably seem unjust, but the fact that such gerrymandering is incompatible with democratic principles does not mean that the solution lies with the federal judiciary. We conclude that partisan gerrymandering claims present political questions beyond the reach of federal courts. Federal judges have no license to reallocate political power between the two major political parties with no plausible grant of authority in the Constitution and no legal standard to limit and direct their decisions. Thus, he was stating that gerrymandering is political and not a question of constitutional law. Justice Kagan, in her minority opinion, shared by 3 other justices, argued, this deprives citizens of the right to participate in the political process. Politicians allowed to entrench themselves in office against voters' preferences. This allows core principles that the voter should choose their representatives, not the other way around, reversed. As you will note, the representatives decided who would be in what districts, and therefore, by packing, denied the vote. Vote dilution implicates the 14th Amendment, equality, equal participation of voters in the election. First Amendment rights of association and political effectiveness are diluted by political gerrymandering, degrading a voter's influence on the political process. The legislature, by gerrymandering, shows specific and predominant intent to entrench themselves in power by manipulating district lines. Her minority opinion concludes, and I quote, of all times to abandon the court's duty to declare the law, this was not the case. The practices challenged in these slides imperil our system of government. Part of the court's role in that system is to defend its foundations. None is more important than free and fair elections. With respect but deep sadness, I dissent. And what organizations wrote amicus curiae brief in support of partisan gerrymandering? States: Texas, Alabama, Arkansas, Georgia, Indiana, Louisiana, Ohio, Oklahoma, South Carolina, and Utah. All of these states have partisan redistricting. The Speaker of the House of Representatives in Pennsylvania, who had lost a battle at the state court level in Pennsylvania, which state court, Supreme Court, ruled that as a matter of state law, Pennsylvania's House of Representatives had gerrymandered in a way that was impermissible and unconstitutional. The state House of Representatives in Pennsylvania appealed to the Supreme Court, but the U.S. Supreme Court refused to grant certiorari because there was no federal issue involved. Remember that. It's coming up next. American Civil Rights Union, this is not the ACLU, it's a conservative group. Southeast Legal Foundation, the National Republican Redistricting Trust, the Republican National Committee, and the National Republican Congressional Committee. So partisanship, as long as it protects the Republicans, is acceptable. And that's what the Supreme Court held. However, there is hope. North Carolina's state court ruled in September 2019 by a unanimous decision of 3-judge panel that the state's redistricting map, which we had looked at before, was unconstitutionally drawn as a matter of state constitutional law. The reasons cited include violation of North Carolina's state constitutional clauses guaranteeing free elections, equal protection under the law, and freedom of speech and assembly. And then, this week, October 28th, 2019, 3-judge panel in Raleigh ruled that the congressional districting by the state legislature was unconstitutional and that the congressional districts would be drawn under the court's control. Note that both state courts based their decisions of unconstitutionality on the use of the same maps that the Supreme Court had looked at in RUCO versus Common Cause. So how do states redistrict? 7 states only have 1 congressional representative, so they don't redistrict for the congressional. Independent commissions, such as California, have commissioners balanced by party and other criteria to follow specific rules for determining redistricting. 4 states use a political appointee commission for congressional plans, and 9 states use this type of commission for state legislative plans. In November 2018, Michigan votes for an independent redistricting commission to overcome their Michigan's state legislature, which was kept redistricting themselves and the congressional districts for the purpose of continuing one party in control. 61% of the voters voted for this. Since then, the Republican state legislature has not funded this effort. The Republican Secretary of State has not issued application forms for the applicants to apply. And now Republicans have sued on the basis of the First Amendment rights because the Michigan Commission, under this constitutional amendment, disallows candidates and lobbyists from applying for the commission. In my opinion, hypocritical. Ironically, the Michigan constitutional amendment to create a nonpartisan commission was cited by Justice Roberts as one of the reasons why the Supreme Court should stay out of redistricting and let the states take care of their own redistricting issues in the RUCO gerrymandering decision. But note, not every state has the power to pass a constitutional amendment by the vote of the people. So this slide just shows the current redistricting where bills of some sort reside in offices. Whoops, sorry. These bills were these bills have been introduced. These bills, sorry, this is difficult. There's something wrong here. Okay. In 2015, however, I want to draw your attention to U.S. Supreme Court decision, which was a 5-4 decision. Note, 5-4 decisions are often terrible. Arizona State Legislature versus Arizona Independent Redistricting Commission. This was a good decision. In the Ginsburg majority, she wrote that the people of Arizona turned to the initiative to curb the practice of gerrymandering. Arizona voters sought to restore the core principle of Republican government, namely that the voters should choose their representatives, not the other way around. The election clause does not hinder this endeavor. Remember, in the election clause, it said that the state legislatures had all rights that Congress didn't take up or which was not expressly stated in the Constitution. However, Justice Roberts, writing for the minority of 4, said that the people of Arizona have concerns about the process of congressional redistricting in their state. Quote, for better or worse, the Elections Clause of the Constitution does not allow them to address those concerns by displacing their legislature, but it does allow them to seek relief through Congress, which can make or alter the regulations prescribed by the legislature. I want to point out the hypocrisy of the Supreme Court decision in Ruco by Roberts, who said that redistricting was too difficult for the courts to uphold, but he overturned a congressional act, sections 4B and 5 of the Voting Rights Act had been overturned in Shelby. And he overturned the, which would have not permitted redistricting to the level that excluded the right of voting under the First Amendment and the 15th Amendment. So how did all this happen? Well, first of all, because money in politics. The Supreme Court decisions of Citizens United unleashed the right of corporations and unions to use corporate money in politics. Minorities have been disproportionately impacted on the exercise of their vote because of the huge amounts of money used to support candidates that openly vote for vote suppression legislation in Congress and at the state level. Tied together with Shelby County's decision, the rights of minority voters have been impaired in the last decade, and money is just one of the reasons. Vote security is another way of suppressing the vote or helping the vote. Under the 2002 Help America Vote Act, certain rules and regulations about standards for voting machines have been set. 16 years later, many states have out-of-date, hackable, and unmaintainable voting machines being used, some without paper trails or the ability to audit. One egregious situation was addressed in Georgia. In 2002, Georgia had received funding under the Help America Vote Act. Georgia chose a computer system which did not have the ability to print a paper ballot, nor was it auditable. They housed the voting system in a university computer facility. California discovered in 2006 that that same equipment that Georgia was using in 2002 and continues to use to this day was hackable and unreliable, not constitutional, and California decertified every one of those machines in 2006. Georgia continued to use that same equipment, and in 2018, in a closely watched election run by the Secretary of State, Kemp, who himself was running for governor, these machines spewed out votes or undervotes. In the vote for lieutenant governor race, 127,000 undervotes were missing from electronic voting machines in African American neighborhoods. That means An undervote means you voted for governor, but you didn't vote for lieutenant governor. However, the paper ballots in the same precincts received for provisional, and absentee votes had no significant undervotes for the lieutenant governor. The federal district court in Georgia said that these voting machines were unconstitutional and they had to be removed and not used in 2020. The court ordered Georgia to have paper ballots and said that they would oversee Georgia's computer replacements. Please remember that Justice Roberts said that it's up to Congress to act. And in 2019, the House of Representatives did act. They passed For the People's Act, which is known as H.R. 1. It addresses voting access, gerrymandering, computer security, voter registration, ballot tabulations, but H.R. 1 is unlikely to ever see the light of day in the Senate. According to the Senate Majority Leader, Mitch McConnell, some of the key features it provides includes access for people with disabilities. It covers automatic vote registration in all 50 states and the District of Columbia. It requires same-day registration in every state. It prohibits deceptive practices and intimidation. It restores the right to vote to felons. It sets out in detail early voting, vote by mail, Absentee Uniform Services Act, and oversees voter rights, and it requires security. Finally, the House passed the SAFE Act to bolster computer security, fully funded and including annual refurbishment money to sustain up-to-date election infrastructure. This bill is in the Senate under the Rules Committee. It passed on June 28th in the House, and at this presentation does not have the attention of the Senate leadership. The House also introduced the Voting Acts Advancement Act of 2019, which was to overcome the discriminatory actions of Shelby County and Holder by including express definitions for discriminatory practices related to race, color, or national languages, and rules relating to Indian lands. This is languishing in the Constitutional Committee of the House. For more information on voter suppression and discrimination in Georgia, please go to the website Brave New Films Suppressed, issued in 2019. Georgia was a covered state in 2013 under the Voting Rights Act. The Secretary of State did not process 58,000 applications for registering to vote. He won by 54,000 votes. This is the Roberts Supreme Court legacy, to bring discrimination back into states and decimate congressional action of the Civil Rights Act and the effective protections of the 14th and 15th Amendments. If you want to get involved, here are some organizations you may contact. National Voter Corps, League of Women Voters, which does not include men or non-voters. Common Cause, Reclaim Our Vote, Mia Familia Vota. On the National Voter Corps website, there is an extensive list of voting rights groups, nationally and by state. I'd like to conclude. That the Supreme Court has taken away the civil rights acts of many voters in America by its ruling in Shelby County, Citizens United, and Russo versus Common Cause. Millions of Americans have had their vote suppressed through vote suppression measures, of which I hope you now have a better understanding. State legislatures are seeking their voters through gerrymandering instead of voters selecting their representatives. There is a legal maxim, danger invites a rescue. Please get involved in the fight for one person, one vote, and every vote counts. Democracy is not a spectator sport. Please vote. Thank you for watching this video presentation. I'd like to thank the Mid-Peninsula Media Center for facilitating this recording on voting rights. And here are some additional slides which I think you might find of interest. I'll continue to talk, but if you want to stop here, that works as well. Strict voting rules. Here's some more examples. Georgia's Muslim voting project is fighting rejection of absentee ballots because signatures didn't exactly match. The court held that the voter must be given a reasonable time to cure mismatched signatures. Arizona tried to introduce two registration forms, one for state and one for federal, but there is no more use of duplicate forms. In August of last year, ACLU filed a lawsuit for the legal voters of Arizona, Mia Familia Vota and others, alleging violation of Section 5 of the National Voter Registration Act. This was settled by a memorandum of understanding to remedy the problem. Arizona agreed to update its registration forms when voters' addresses changed on a driver's license. I'd like to go further into what happened in North Dakota. Native Americans on reservations don't have street addresses. And when she said that tens of thousands of North Dakotans were going to be deprived their right to vote just because their culture did not have a street address is outrageous. And this was on the voter ID. It's not on the registration form. You can register to vote by just putting your a cross corner. Homeless don't have a street address. They may have two corners of an area. Kansas provisional ballots. Kobach, the Secretary of State, won the Republican nomination for governor by fewer than 350 votes, but more than 800 provisional votes when he was the Secretary of State had not been counted. Florida's law provided, was shown to have an intentional discrimination based on age by not allowing any early voting sites on college campuses, and that was struck down. Here are some of the sources. I want to thank these outstanding organizations, the Bremen Center for Justice and Ballotpedia have maps, most of which I have screenshot and saved on these slides. Go up there, look at what they've done. The rest of these organizations are ones which are clean hands and very important to saving our democracy. Verified voting is not on there, but it is looking at the security of computers. Thank you very much.